Well, hello, Lyric Armstrong, your real estate agent and advocate. We're going to go pop into Judge Simpson's landlord tenant court just real quick. I mean, it's fun times, right? We're here to learn as much as we can relative to landlord tenant real estate matters, probate matters, things that will affect us in a sense of growing generational wealth through real estate and or the things that can cost us in that regard. So come on in, let's get ready for court. Make sure you like, share, and subscribe because inevitably there's someone that you need to share this with and they don't even know that they need it. But until you share on your platforms, they're not even going to ask you about it. Hopefully, because otherwise they might be asking you to borrow money. All right, Judge Simpson, we're going to make sure that we take care of our housekeeping and go ahead and like his video. And Judge, we're ready for court.
Here, Honorable Judge J. Cedric Simpson, presiding.
Good morning. You may be seated. Court calls the case of Beal Properties versus Paramount Sosa Lopez. I think we have an interpreter on this. I have the interpreter sworn, please.
Raise your right hand. Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially using your best skill and judgment and to translate from English into Spanish and from Spanish into English in the matter now before the court, so help you God?
I do.
Good morning.
Morning.
Who do we have on there?
Good morning, Your Honor. Min Kim, on behalf of the defendants. We're both present in the court today. As a preliminary matter, Your Honor, well, I don't know if you want the interpreter to translate what I just said first.
Yes, well, whatever you're comfortable with. We can either do that, or if he's sitting between them and interpreting, I'm fine with that also.
Oh, okay.
Here he is.
That's a little different just because the record is being taken. And so to have the interpreter there interpreting, it's okay, but I don't know. I've never seen an interpreter whisper to who they're interpreting to. Usually it's required that they do it on the record so that if there's any discrepancy in understanding, it can be evaluated whether or not the interpretation was correct or not. It may be in this instance, since they're not being called as witnesses, that it's not prevalent or required for Judge Simpson, because he's really much a stickler about allowing the interpreter the space and time to repeat what you're saying in the preferred language of whoever the litigant is. So anyway, this is getting ready to get spicy. So let's see what's going on.
Are you here for Beal?
Yes.
What's
They're shuffling in. Look at the pug in the background. It's so cute.
State your appearance, please.
Brent Ingram on behalf of the plaintiff.
Oh, yeah,
They're
that's right.
cute, but
You.
that's
Your Honor, we're here first. Well, this was scheduled for a pretrial, but I think the notice says that it was for a settlement conference, which I think was an error, but I have a motion to withdraw from the case, and I'm requesting that be heard first.
That be
Heard first.
prior to, I think, plaintiffs moving to dismiss.
Your Honor, there are counterclaims in the case, so I would say that even if plaintiff dismisses, because I think they have a complaint for possession and the defendants have vacated, that their counterclaims would still survive.
Okay. So a motion to be removed from the case is obviously, as it sounds, the attorney wants to no longer represent them. And you have to, once you're already on the case, you have to present to the court and put a formal motion to the court. A lot of times it can be done in writing with a written motion, and a written order doesn't necessarily need a hearing, but it depends on how far along you are in the case and if it's going to be something that puts a disadvantage to the litigants that you're no longer representing. And there has to be validity to you wanting to step down in that regard. A lot of times counselors will quote the fact that they haven't been paid, and they're like, the bill is gotten 3, 4, 5 times down the road. It's extreme, it's enormous, and it's very unlikely that I will get paid in a timely fashion because it's been so long. So that will be a lot of the reason why they want to be removed from the case. But if you are too far into the case and you're getting ready to go to trial, you may find judges that will deny such motion just because it will put the litigant too much at a disadvantage to try and start the whole process over, because discovery and different pretrial motions, such as things that will go through motion eliminate and pretrial concerns, are such an extensive process that when you're ready for trial, having a attorney pull out can be extremely difficult for the whole process, including that for the court, because it's time consuming and financially consuming on their behalf as well. But her reason is more along the lines of lack of communication. And I'm not sure if there's a language barrier between them or just communication from they're just not answering the phone calls. Let's see what's going on here. Okay, he's interpreting.
I'll hear your
Like
motion.
I'm
Go
interpreting.
ahead.
Well, Your Honor, there's been a breakdown in the attorney-client relationship, and I would hesitate to say any more than that at this time. And so Legal Services is requesting permission to withdraw from the case.
Legal services, no less. So this was
Do
appointed
either
by,
one of the defendants want to say anything regarding counsel's motion to withdraw?
You could allow us another hearing to get a new attorney. To appoint a new attorney.
okay.
Do you have any objection to Ms. Kim withdrawing from the case?
Yes. No.
All right. Your motion to withdraw is granted.
Thank you, Your Honor.
Oh, I didn't know. So I didn't see that far ahead. I didn't know that it would survive because there is a dismissal being ready to be filed. But as Ms. Kim stated, that there is a countersuit. Countersuit, for those who may not be fully aware, there's a complaint that is filed. That's like the first action. And that has a plaintiff and a defendant. And you can have more than one in each one of those categories. But the plaintiff is the one who is bringing the complaint against the defendant. And then the defendant will either just respond and, go through the process with the plaintiff, or if they find or believe that there's others that could in fact be liable in some way, they'll bring on a countersuit. A countersuit could be a third party, have them be responsible, or it could be a countersuit up against the plaintiff saying, no, I'm not the one who caused the problems. You caused the problems. Whatever those problems are, it could be contract, it could be anything. This, of course, is landlord-tenant. So this is the tenants suing the landlord. Well, the landlord sued them for possession. They have possession of the property, and now the defendants want to sue the landlord in response for whatever. I don't know what their particular countersuit is regarding because it didn't go before the court today. But that is what a countersuit is. And so even though the landlord's ready to drop the possession charge, which is the complaint that they had, these litigants still have more matters to go before the court. So they're going to have to get a new attorney to help advocate for them for that.
With reference to the rest of this case,
Which is going to be interesting.
As regards to the rest of the case, Your Honor, we move to dismiss without prejudice.
All right. We knew that was coming.
before I grant that motion to dismiss, what are you two intending on doing with your counterclaims on this matter?
Okay.
We're here because they didn't want to take the guarantee, what we owed, we had the warranty, we had the guarantee of the deposit, and it was equal to what we owed. And we didn't take. Other than that, also we have most psychological problems and emotional problems that we received during that time.
So you wish to proceed on your counterclaims?
So then I get on with it. Yes. Also because they didn't, like we received in a letter in the mail saying that they weren't going to return the deposit for us.
Okay, so they want their
How
deposit.
long will it take you to get an attorney?
2 weeks.
Okay, well, give me 3 weeks. I'll adjourn this matter for final settlement conference on the plaintiff's claims to October 10th. October 10th, 2023 at 9 a.m. in person.
Understood.
The counter,
Get that, sir?
I did, Your Honor. Thank you.
I will grant the plaintiff's motion to dismiss their case for possession, and I've signed that over.
got it.
Judge.
All right, thank you.
Thank you so much.
That's gonna be fun. All right. Take care.
Okay, so they will come back for their count.
Where'd he go?
The interpreter.
Mr. Hughes? I don't know where he went. Miss Kim, is she still in court? Okay, Miss Kim, were you ready on your other matters
Yes, Your Honor.
with Mr. Hughes?
Yes.
I know you are. Is Mr. Hughes ready? I guess it's probably my question.
Was in the courtroom earlier.
Yeah, I saw him stroll through, but I don't know where he is. Okay, is anybody ready on anything? I mean, I am.
Go out in the hallway.
All right. You're ready on that one? Okay. Call that. Court does call the case of Beal Properties versus Christine Thompson.
So we talk a lot about how Judge Middleton is following the appeals. I'll say request. Usually it's, directive, but just say request because he seems to be the only one following it. But he'll follow the time in a sense of each litigant gets a specific time to come before the court. As you can see, Judge Simpson is doing block time. So several people are in at the same time. And this is one of the reasons why sometimes that does work to your benefit, because you could have been maybe the 5th person on the docket that day, but yet here's Judge Simpson saying, hey, is anybody ready right now? And you're like, yeah, we're ready. So you might get out earlier than you usually do. So there's a catch-22, pros and cons all day long relative to how they are setting it up either in block or, in a specific time. So, who knows what's the best one, but nonetheless, they both have pros and cons.
Good morning, Judge Brent Ingram for the plaintiff.
Your name, ma'am? Okay. All right, what are we doing on this case?
Your Honor, we have reached an agreement where we will be submitting a conditional dismissal, and the term shall be that the defendant shall vacate not later than October 19th, 2023.
All right. Is that correct, ma'am? All right. And have you signed that, or has that been prepared and signed?
We just came to this agreement, Your Honor, so I'll be drafting it later today and submitting it.
All right. And ma'am, you understand that's the full agreement? You understand that that's the full agreement?
Yes, I do. The only thing I was upset about was the fact that he has cameras up in my house.
That what?
He has cameras up in my house. Beal does. They have it in the bathroom, in both bedrooms, and in the living room.
Okay. I don't know about that. I will just say, you don't have to enter into this. You want to enter into it. Okay, very good. All right, I will advise you that upon its signing by me, you have 3 business days to think about that conditional order of dismissal. If you decide that there's some right you haven't asserted, the right to a trial or the like, or there's some confusion or misunderstanding on your part, you'd have to file a motion within 3 days of my signing of the conditional order. You understand that, ma'am?
I can do the trial.
Pardon?
I can do the trial.
If that's what you want to do, you can.
I'll do the trial.
Okay, so you don't want to sign the conditional order of dismissal.
Deja vu, I swear. Every defendant, tenant, please get an attorney, please, if you can. I know it's not the easiest thing to do. It's costly, it's time consuming. But if you can have legal aid represent you, please do, because here we are. Once again, here's another litigant getting ready to get a conditional dismissal, which the last litigant that we saw was on the last video, he was talking about a consent judgment. To me, that's a little more egregious just because it still goes on your record and it shows that there was some kind of dispute that ended up getting resolved and you actually conceded to what the dispute was. You're not fighting facts. And a conditional dismissal is under certain conditions, then the plaintiff will just dismiss the case. And therefore, what's on the record is that there was some type of complaint against you, but it was dismissed. And therefore, there's nothing to say that there was any legitimacy to the facts. There was nothing to say that you somehow was a bad tenant because it got dismissed. So you could argue that there were no merits to the case, and so they dismissed it. So that's why I prefer conditional dismissals over consent judgments for the tenant's rights. Now, landlords, of course, they're not so much because they want to have a track. Consent judgments are better for them because then there's a record. Nevertheless, this one here we go in the hall, everyone makes the agreements in the hall. In the hallway, they come to an agreement, they're going to do a conditional dismissal. And this young lady says, nope, I don't want to do it after all. I can have a trial. You mean I can have a trial? That's availed to me? That's something she should have known because she should have been able to talk to attorneys some time ago relative to what her rights were. So I'm glad. And as always, the judges do a great job at making sure that the litigants understand what their rights are before they make these sign these judgments into order, because otherwise this lady would be confused about that factor. But always get an attorney, because legalese it's not English, it is and it isn't. So by all means, get an attorney to help you understand the process.
All right.
Poor guy. He's like, I just got her to agree. I just got her, and it's like, no,
What
not
is the
really.
basis for termination in this case?
Essentially failure to abide by the rules and regulations, Your Honor. There have been several incidents involving smoking. I believe there were some marijuana plants cited. There's a report of an unauthorized occupant and an unauthorized dog as well.
There
So
was never any.
Well,
No, don't interrupt. Another thing is what she reports relative to cameras and privacy violations is something she needs to report to the police, so she can have a incident report and go through the criminal court, not necessarily landlord tenant, even though they will coincide at some point. But now, same thing with him. If there is I don't know what the legalities are relative to marijuana plants in Michigan. But even if there is, say it's legal in Michigan, if the landlord is saying it's prohibited on their property, you still can't do it on their property. So then they should be reporting her legally, right, for breaking the lease. But let's see,
hold on, ma'am.
or the law.
All
and
right,
the lease.
ma'am, have you filed a written answer to this?
Doesn't even answered.
No, you haven't. Actually,
She needs a
today is the
delay.
date for the trial.
Today's the
You
day
want a
for the
trial today, ma'am?
I'm not ready for it today.
It's set today.
trial.
Then we'll just go with what you teach.
All right, you understood the rights as I explained them to you? All right. I will indicate this case is conditionally dismissed. I'll await the order. Thank you.
thank you, Judge.
No trial. So Judge Simpson and the judges before typically will give those same rights and understanding prior to setting trial date. So her failure to answer in writing, and then that was the trial date that she's not ready for. It's like you can't say you want a trial and today's the trial date and you're not ready for a trial. So I guess judge is like, nope, conditional dismissal, and we'll just let it go. But once again, if there is some privacy violation in some, like cameras are not allowed to be in the bathroom, they could be in common areas. So if there is some invasion of privacy relative to that, then you most definitely can go to the police and file a police report against whomever is violating that privacy, landlord or other tenants, whomever that is.
Why is he shaking his head at me? Don't call his case. He's got that look on his face. Mr. Hughes, are you ready on your cases?
Always ready.
Yeah.
Always ready.
No.
That's a good answer. I'm always ready for you, Judge. Whenever you're ready, I'm ready.
Did you wish me to call these together or individually,
Your
counsel?
Honor, Ms. Jones has a motion up before the settlement conference. If we could have that heard first.
Any objection to that, Mr. Hughes? If you want Mr. Fink to move, you just have to bump him over. He. Court does call the case of the Forrest Knoll versus Ashley Jones.
Kim, on behalf of Ms. Jones.
P 31986, appearing on behalf of the plaintiff.
Your Honor, this is Ms. Jones's motion to amend her answer and counter complaint. Your Honor, due to her counsel's fault, she failed to assert one of her claims, which was for repairs. She had a really bad flooding in May where her and her 4 children had to evacuate the apartment for over a week. And the court rules state that leave shall be freely granted if justice so requires. And also that absent showing of any prejudice to plaintiff or actual bad faith, that the delay should not cause a denial of the motion to amend. So we're requesting that she be allowed to add this claim, and I have submitted an amended answer and counter complaints.
Okay, because they're gonna go fast and loose. There's a lot of legalese going on right now. So this attorney or whomever was in representation of the litigant at the time failed to put certain assertions in the answer. This may fly, it may not fly, but for everyone who has an attorney, you still are responsible for the attorney's work. So you must read it. There's a paragraph, it's called the prayer paragraph. It talks about what relief is necessary. It's usually towards the end. That gives you a good idea if all things were listed and itemized within the answer relative to what you want done. So if you don't see the word repair or relief for repairs in that particular paragraph listing, then it's probably nowhere else in the answer. But make sure you read it cover to cover so you can make sure that whatever documents are being written on your behalf actually do represent your position. She said this is an amendment. She wants relief for the delay. The delay is because she's out of the statute of limitations for the amendment. It's gone too far beyond. So she's saying, please don't penalize the litigant on this factor because it was the attorney's fault. She's taking the blame, even though, like I said, you ultimately are responsible for your attorney's actions because you're supposed to oversee and double check them and make sure that they've asserted everything. And sometimes you don't know the legalese, but you just say, okay, in here, where does it say that on September 13th, XYZ happened? And then they'll go to the paragraph. Here, it's on this line, and then you read it that way. Okay, now here's that was the defendant's attorney bringing up the motion. So the responding party is the plaintiff, and here he goes.
The response is there were kids' toys in the toilet that caused water to seep into the bottom toilet. We were late in the game in this, Judge. This was a recertification issue. We're at the end of the finish line with the recertification and negotiating a final resolution. This should have been brought months ago when this case was first started. We would ask that the request to amend the complaint be denied at this point.
Okay, so his answer is pretty straightforward, not too much legalese, but he's basically saying that the cause of the issue was on the tenant's causation, like she's the reason for the flood because her children had toys in the piping, whatever. So he said the toilet pipe. Maybe, maybe not, but you gotta fix it. So how long did it take to be fixed? Who knows, whatever. But here we go. Judge shall come in and rule. Let's see.
I guess I'm a bit concerned because this is,
I think there was an escrow requirement with this one too, and I'm not sure if the escrow payments have been made.
I have one escrow payment in July. That's all
In
I
that
have.
case, we would ask that the jury trial request be waived
I
and
think-
set the matter for immediate trial.
We're confusing the
Your Honor, I
motion.
don't think there was a jury trial request on this matter. Also, there has not been really shown any prejudice to the plaintiff who's known about these repairs the whole time. And I believe they finished the repairs after our last final settlement conference meeting, I think around August.
But I guess my problem is, I had this set for, on June 30th. I set it for final settlement conference on August 8th, 2023. June 16th, however, I don't know how that happened, but in any event, I've had 1, 2, 3, 4, 5 hearings. And I've adjourned this out, and now I'm here on a motion to amend.
I understand it's late, Your Honor, but I believe that justice requires that she not be prejudiced because of an omission on my part.
Prejudice is penalized, okay? I mean, just in case you don't know.
But, okay, but the problem is that as this has proceeded along,
So I think what the judge's concern is, they've had several meetings within the months, like they had several hearings, I should say, within the last few months. Whereas it's like, okay, she heard the hearings, she was there, we talked about everything else. Why at no other time was this amendment done? Why is it so far down the pipe? What Counselor Kim has in her favor is that the plaintiffs have known about it. It's not like it's something new being brought to the party. It's new to the judges table, which is quite unfortunate, but it's a good thing to be able to say, the opposing counselor has been informed of this issue long ago, and they had been working on it. It's not something that was new to them. So they are not in any unfair territory, which is having something alleged against them without prior warning so that they could defend themselves. They've known of the issue a good substantial amount of time. So this is not something unknown to them.
I mean, yes, it should be freely granted typically, but this matter began in May, and now I'm here in September, and you're asking to amend the complaint. Motion to amend the complaint is denied.
Oh, so unfortunate.
I think you guys are too late on it.
So unfortunate. And now this goes to why did she not do it? And according to Ms. Kim's representation, it's of her own omission. It's of her own fault that it was not done. So the litigant, if she feels like she is losing some legway or some type of remedy that could have been awarded to her based upon this, she could file a grievance against Ms. Kim and get a hearing up against the bar for disciplinary action. That if found, that Ms. Kim did something nefarious or did something, problematic and causing her an issue in this case, could be awarded some funds relative to that, which would be the reason why all attorneys have malpractice insurance or errors and omissions insurance for real estate agents, and medical malpractice for doctors, because mistakes happen because they're human beings. It's quite unfortunate. Ms. Kim did do she did do something to try to bring it forth, because it's not as if the case is closed and she's coming back to amend, but the time frame is so extensive, the judge is just not going for it. I don't know. And then I guess, like I said, Ms. Kim can defend herself if she does go to the bar against her. She can defend herself by saying, we are both advocating for the litigants, for Ms. Jones. We're both, me as the attorney and her as herself, are both advocating for her best interest. And at no point during these several hearings and these several motions and whatever was going on with the case throughout this time frame did she, bring up the fact that the answer did not have this particular assertion. The other thing is, certain complaints require that you do a verified answer, which means that the individual who's answering, that defendant, verifies that this is a correct and full, complete answer. So if she signed that document, then that would be something that Ms. Kim could defend herself on too. But it's unfortunate that the litigant is not going to get this particular issue heard before Judge Simpson, because repairs are a big deal. Fault and all of that can be sifted out, and it can go either which way. They can put the blame on her and her children with the toys, or it could be the fault that toys or no toys, you were informed of it a long time ago and you didn't take proper remedy within the reasonable time frame. But we won't get anywhere near that at this time. Maybe in appeals court, but not here.
All right, what are we doing on the case?
Your Honor, we're here for the final settlement conferences in all three cases, and we're ready.
You'll recall the last time we were here, we had negotiations, thorough negotiations where plaintiff graciously agreed to not charge legal fees or late charges, but are required to get paid the rent per the HUD regulations. They offered a payment plan as well, and that's where we ended up.
And what's happened since then?
Your Honor, I don't think the parties have changed our positions from the last meeting, but I don't know if meeting again might change people's minds.
In terms of the structure, are the parties in agreement on the structure of what will happen? Or is it a number that we're?
So I think the issue comes down to one issue in all three cases is when the recertification will take place and when they commence their recertification and whether or not they receive their proper notices. They're claiming they did not receive their proper notices. Plaintiff takes a contrary position. As you know, they send out multiple notices and in this case, hand delivered and mailed notice of the increase to market rent. They're seeking to retroactive the rent to when they told the landlord that there was a change in circumstances, or when the annual recert was done, even though they didn't complete it until months and months later. And that's really the issue before the court.
You agree with that? I mean, that
not
sounds
all
to
of
me
them.
like that's an evidentiary hearing. I mean, that's what it sounds like to me.
Yeah, like,
Well,
did it?
I suspect that we may end up going to trial, but
Well, then let's just set it, because I'm not gonna keep going around in a circle then with this. I mean, if the last time you guys were here, there was a basic structure to what's happening. Now we get here today and I got something totally different.
oh,
So
I
the
don't
structure
think,
was the same. I think we gave as much as we could give at this point.
I'm not sure what you mean by structure, Your Honor. Do you mean a payment plan? Is that what you mean by
Well,
structure?
of how this was all going to occur. If there's maybe I'm in error. If the structure is there, it's really, we're talking about a number.
That's correct. I think that plaintiff had offered a payment plan, but would not really come down on any of the market rent that the tenants are so adamant that they never received the notices that they're willing to try to compromise, but not if none of the amounts are reduced.
I
I don't know how much of this you want us to, discuss with you right now, but
So we waived all the things we can waive, the rent we can't waive. And I think that's what Ms. Kim is looking for.
So what do you guys want me to do? I mean, I'll set them
Do
for
it.
trial. I mean, it just sounds to me like,
I think an
Sure.
evidentiary hearing would be fine. It's a simple issue when the research takes place and whether or not they received the proper notices.
well, I don't know if it's that simple, Your Honor, but if
well,
I-
it's not that
I see it
simple, then we'll
wouldn't-
set it for trial. I've got to do something with this other than like have you come back and tell me you guys can't agree. So,
Well, Your Honor, it wouldn't hurt for us to try to talk again momentarily. But if we don't resolve it today, I would say definitely would like to schedule a trial.
okay, if that does that include me or just you two?
Okay.
However, the court wishes to.
Well, I don't want to be in the room with you two, but I mean, I should have said that out loud, right?
Of course,
Well, why don't you-
having you there would be helpful.
Why don't you two, can you guys talk and see if you can work the number out?
Yeah, I've gone as far as I can, Judge. We're restricted by HUD regulations. It's either a thumbs up or a thumbs down for her. And I think she's looking for a compromise in the rent. We can't do it. So I think we'll have to set a trial date. We've waived the late fees, we've waived the attorney fees, everything that we can do, we have done. We've offered a payment plan. I can't do anything more.
Is that how you see it or no?
Well, and the other thing, Your Honor, when we were here last, we only talked about Ms. Johnson and Ms. McClure's case. And because Mr. Huth had to leave, we never even got to discussing Ms. Jones's case.
But I thought that in essence, the issue was the same on all of these cases.
Yeah,
That's
other than her
correct.
amount is $12,000, so it's probably a payment plan won't work. So I suspect we're gonna have to schedule this for a trial.
Okay, but what about the other two cases?
The other two are
Now,
small amounts. 1384 is for McClure and 2971 is for Johnson. We've agreed, like I said, to waive the court costs, waive the late fees, and offer a payment plan.
So you want me to set those also, Ms. Kim, for trial?
All three matters, Your Honor. But I ask again for an opportunity to have further discussion today.
Okay, well, why don't you guys start? I've got some other cases I'll handle and
Give
then,
us a trial date, Judge, so that after we're done, we can go.
no, because then you won't negotiate in good faith. Go out there and see if you guys can reach a resolution. I mean, and then I'll have you back when I can do it. I mean. Thank you.
Thank you.
Okay.
All right, fun times, huh? Let's see if there's anything else to close with that.
Ms. Cam,
Yes.
you might want to tell your client she needs to check herself before she leaves my courtroom in that fashion. Thank you.
Oh,
She needs to check.
wait a minute.
I mean, and then I'll have you back when I can do it. I mean,
We don't see.
thank you.
Thank you.
Okay.
Ms. Cam,
Yes.
you might want to tell your client she needs to check herself before she leaves my courtroom in that fashion. Thank you. Otherwise, she'll be going with you. Miss Riser, you lost? Yeah, no, I've got a civil docket. You want to play?
Sure, I'll take care of all the.
Okay.
We were looking for an interpreter in courtroom C. I thought maybe they were.
Was it Spanish?
I didn't ask the language.
Okay, I don't think we have a stray interpreter. We had a Spanish interpreter here this morning, but that was on our case, so.
I can do what I can do. My still. Thank you.
All right. Okay, I don't know. So here's the thing. It's like, doesn't look like Zoom court per se, but yet we're still live streaming. And the beauty of that is we get to still see it, but then the problem is we have the mic issues, right? Because I don't know what the litigant said as she walked off. But it sounded like she was saying something, and whatever the mic in the room was doing, it just was not picking up exactly what she said. Picked up some kind of crumbly, shuffly thing, and then we had some other people talking, and then someone else is messing with papers near a live mic, and so we're back to those days. So that's why we keep the sound up as loud as we possibly can, just in case we're able to hear what is being said, but it's look like a full courtroom. So the sound is a little difficult. But whatever the case, she got admonished in the end. I believe she was having a breakdown during some of the communication. I would assume she feels disadvantaged because sounds like one of her major issues dealing with the repair and the repair not being dealt with for a very extensive amount of time, at least between May and September now. So August, I think, was when they said they actually finished the repair. So it's a long time to have flooding and issues of flooding throughout the property. But so, whatever, she's probably upset. But you never have a right or a reason to disrespect the courtroom. And if you want the judge to have any sympathy towards your position, you won't disrespect his courtroom, right? Take it outside, vent to someone else, hold it in, whatever you got to do. Okay, so the plaintiff's attorney kept speaking of they failed to recertify. And so they had notice of recertification, then of course they have annual recertification. So they're getting rental assistance of some sort. And I was thinking it's probably Section 8 or somewhere they're getting assistance, and consequently you have to turn in your certification paperwork that represents how much income, how many individuals are within your household, so that your rate is recalculated ever so often. And the gentleman said it's an annual certification, but I know some certifications that are every 6 months. So I guess it just depends on which certification he's talking about. He professes that the landlord was sending out the notice for recertification paperwork. Maybe they wanted the copy that they need to send over. I'm not sure the process that they're doing, but it sounds like the landlord was sending it to the tenant, and the tenant was not responding and not giving them the information. He professes that they gave it to him in hand. Not sure, because there's 3 people, 3 different cases. I don't know if they live in 3 different apartments or if they live together. Like that's something we'll have to find out. But we'll keep watching and see where we land. He does not seem to think that there's any rental adjustments that can be made. But this is where we say this status conference for settlement, right? This settlement conference that they're in. That's the process that they're in right now. If they go to trial, meaning that they set it for trial, then they'll have evidentiary hearings that will sift all of those particulars out. Because right now they're just asserting these as facts, and if they don't get to a point of settlement amongst themselves, then they have to go and prove these facts to the court for the court to become the fact finder and make the final judgment call. And plaintiff's attorney is pretty much like, look, I know it is what it is. I see what it is. And quite frankly, there's no adjustments to be made. I don't see any need for another settlement conference conversation, because we're past settlement, because you won't accept the agreement that I can give you, and I'm giving you the best I can give you. Ms. Kim's not having a good day. So far, it's a little rough. I'm sure her client is upset with her. And motion's denied, and now settlement is still a fantasy. So hopefully when they get into the back room, things will change and conversations will be had. And maybe she can make some more reason of the fact that if we do go to trial, maybe I will have better luck at being able to present the fact that you guys failed to keep the location habitable for several months. I don't know. She lost emotions. I don't know if that's going to work for her. Anyway, this was interesting today. Judge Simpson, as always, is demanding respect and decorum to be conducted in his courtroom, as always, whether in person and or on Zoom. As you can see, we're in person. We're live and in person. So thanks to Michigan Judge Simpson's court for always letting us get our public viewing through this live stream. We appreciate that. I am Lyric Armstrong, a real estate agent and advocate. Please do me a favor, make sure you like, share, and subscribe. Share this out. This was a great lesson. Great lesson for anyone that's in legal period or going to have any type of legal encounter at all, that even though your attorney is the educated legal scholar that can strategize and, you know, put things in the legal format and the legalese, the words that are meant for the courtroom and to, you know, put forth your claim or your response, you are still responsible for the final outcome of what they produce. So you have to double check it. And that can be really hard if you don't understand the wording. So my suggestion is that if you find yourself like legalese is just not your jam and it just makes your head hurt, sit with your attorney and say, we need to go over the documents before you file them. I don't understand legalese. I want to be able to sit down and I want you to show me within the document, it reports what I'm telling you so that, you know, you can make sure it's in there. Because if you're signing the verification form, that means you're verifying that the document is true, accurate, and complete. Meaning that the information, whether it's discoverable information or it is the answer itself to the complaint, that this document, this particular information has all the information necessary relative to the questions, and that it's a complete understanding and that it's completely honest. And then when you sign that verification form, that's you as the litigant verifying. So like I said earlier, some complaints require that. So make sure we spread the word, because a lot of times people feel like, oh, my attorney is handling it. My attorney is handling it. I don't care. You still need to read it for yourself. If you don't understand the language, then you need to have your attorney go through the pertinent parts so that you can understand what is being said and you know that everything that's there is meant to be there, or, you know, whatever have you. Because at the end, it's going to be your caboose on the line. Even if you're not responsible for the work product that your attorney dishes out, we get to court, the outcome affects you more than the attorneys. It's your life. So, you know, do yourself a favor and be informed about what's going on in your life. Okay. All right. Like, share, and subscribe. Get this word out so everyone can be informed relative to the necessity of reviewing and maybe revising their answer in legal documents. Lyric Armstrong, see you at the next video.